Mr. Kirschner.
Thank you again for this opportunity to address you, this time with respect to the NPRM's changes with respect to board review.
I'm really getting to know you.
You're one of our repeat players, and I thank you for that. There are two significant sets of changes that the board is proposing with respect to board review. The first it deals with further limiting board review prior to the election, also referred to as interlocutory review, in place of the current discretionary standard. The second is with respect to changing the board's post-election review to a discretionary standard. In our view, neither change is warranted or appropriate under the law, and moreover, neither change we think would have any substantive impact on expediting elections, but rather would only truly end up impairing the fairness of the election process. With respect to the pre-election board review, the NPRM's proposal to eliminate the current discretionary review in place of an extremely limited special permission standard apparently, it is not entirely clear from the NPRM, but apparently would effectively preclude pre-election review by the members of the board, rendered by hearing officers and regional directors. This is especially concerning given the enhanced discretion that is provided to the regional directors and hearing officers elsewhere in the NPRM. This delegation of authority, we believe, is inconsistent with the 1959 amendments to the Act, in particular Section 3B, which enables the board to delegate matters to a regional director, subject to the right of the parties to seek board review of any action by the regional director, including requests to stay elections. In this way, a board proceeding, because of Section 3B and other components of the Act, is different than the way in which a federal court litigation proceeds. There is nothing like Section 3B with respect to the role of circuit courts and district courts. And for that reason, I think that the analogy to federal court litigation is flawed with respect to this particular issue. Pre-election decisions currently subject to the board's discretionary review include many critical issues such as unit scope, supervisory status, voter eligibility, particularly in the healthcare field with large units, complex determinations of supervisory status. Discretionary board review of such pre-election issues serves the purposes of the Act by enabling the board to take action when necessary to avoid obvious errors being made by the regional directors. Although the great majority of regional directors and their staff are performing their jobs admirably, errors do sometimes occur. Maintaining the board's ability to step in prior to the election when it concludes it should do so helps avoid unnecessary litigation and subsequently rerun elections after the disputes are resolved. Limiting the board's discretionary pre-review to the special permission standard is not likely to have any substantive benefits to the process. The board rarely grants such review, as already noted, issuing them only in relatively rare cases to avoid situations in which the board would likely need to rerun the election if it were to occur. Moreover, the pendency of the request for review does not substantively interfere with the issuance of a direction of election. The board's internal procedures for reviewing the request for review are the board's internal procedures. You can modify those. Therefore, eliminating this discretionary review would not, in our view, by itself expedite elections, but would in certain circumstances allow elections to be conducted that inevitably would only need to be rerun. With respect to the post-election review process, the board seeks to make a major substantive change by leaving this review entirely to the board's discretion. In the view of many employers, the board, by doing so, would be merely attempting to avoid statutory obligation to review and correct disputes under its jurisdiction. As a preliminary matter, it should be noted that this proposed change only affects post-election procedures, so it doesn't affect when elections are conducted. It's obvious, based on the process currently in place, that parties in board proceedings would much prefer to have an opportunity of board review, as demonstrated by the number of stipulated election agreements rather than consent election agreements. The proposed rule change is also especially problematic given the extremely broad discretion elsewhere in the NPRM that enables hearing officers and regional directors to make many issues that we believe would make it more likely that the board should actually conduct a review in a case. Finally, this proposed change is only likely to delay the commencement of true bargaining relationships. If the board decides not to review a post-election dispute, the appealing party is likely to feel that it has not had a real chance, a real review of this dispute. This will, in our view and our concern, promote the use of technical 8A5 violations so that the board, and perhaps a court later, will be required to review the dispute. In these types of cases, the employer is essentially required to engage in activity that they know will be considered by the board to constitute an unfair labor practice charge in order to obtain review of an issue that presumably could have been resolved during a representation process. But the entire technical 8A5 process is problematic. It's extremely slow. It exacerbates disputes within the workplace. It delays bargaining between the parties. For hospital employers especially, the technical 8A5 process can be problematic. Hospitals need to preserve, as I've stated before, a tranquil, healing environment throughout its care of patients. The longer disputes exist within the litigation process, the more disruptive that environment is going to be. As leaders in their communities, hospitals are generally reticent to be seen as violating the law, even for technical reasons. Moreover, many hospitals are sometimes evaluated based on lack of legal violations. For example, a hospital's magnet status, a recognition program operated by the American Nurses Credentialing Center, or a hospital's accreditation by the Joint Commission could be questioned by having unresolved violations of the NLRA, even if they are considered, in our parlance, technical violations. For all these reasons, the board should not limit further its review of disputes either prior to or after an election. Thank you.
Mr. Kirschner, you know, the 3B indicates that any action of the regional director is subject to potential, party potential request for review. In the proposed rule, it kind of interprets that under the special permission standard, a new narrower special permission standard, as meaning the board would consider pre-election requests for review if they would otherwise evade review. And this is in the category of me asking, what our own proposed rules mean. Have you given any thought to any examples of what that language means in the representation election context? What kinds of issues do we have that might otherwise evade review and therefore still be subject to pre-election review under that new standard? And I'm not suggesting that you should be able to come up with examples, because I haven't quite figured that out, but I was wondering if you have.
Well, I've thought about it, and I have two areas of concern. First of all, the evading review standard needs to be looked at with respect to the other component of your proposed change, which is the discretionary review of the post-election process. So would it be evading review if, in fact, the mandatory review right now post-election becomes discretionary? So that's one particular issue. I also think that I do not understand, in having read the board's rules, exactly how a special permission standard varies from the existing discretionary review standard. Looking at the percentage of cases in which review is granted and how small it is, I'm not sure how it could get much smaller and still be some sort of review. It almost appeared to me that the board acknowledged that 3B requires some type of review. And so therefore it established on its face the special permission standard. But it also was doing so by trying to even limit further the standards that currently exist, which seems to me to be just an apparent attempt to cover the statute by saying, yes, we have some review, but it's so extremely limited that, in essence, we're never going to grant it. So if there's true review still possible, I don't understand why the board needs to change the current standard. It could still have discretionary review and make its discretion, of course, whether to grant a review or not, and thereby obviously still comply with Section 3B.
Thank you.
Thank you.
Thank you.